Good afternoon, everyone. My name is Alexis Alvarez, and I'm the Director of Statewide Training at Florida Legal Services. I'm extremely excited to welcome you all today to Attorneys for Children, Oh My, Florida Law, Data, and a View from the Bench. Thank you all for joining us today. This is going to be a great learning opportunity, a fantastic discussion, and really cool statistics and really just more than surface level stuff. So thank you for joining us. And of course, always thank you to our speakers. Before I move into introductions, I want to go over some housekeeping announcements as always. First and foremost, this is being recorded. And all of you who are here today will receive a copy of this recording. That recording will come to you in the form of an email from Zoom, and that will come within 24 hours. But I am going to drop my email address into the chat. That way, if you don't see it, if it got eaten up by your junk box, or you just have any other questions, you can always email me directly for absolutely anything that you need. Second piece of housekeeping announcements are CLE credits. This training has been approved for CLE credits through the Florida Bar. That CLE code is something that I will announce at the end of the presentation, but additionally, that CLE code will be provided to you all along with that recording in that same email from Zoom. Additionally, if anybody needs a certificate of attendance, that is also something that I will be able to provide individually. So after the event, email me. Like I said, my email will be in the chat, and I will make sure that you get your certificate of attendance. Two more pieces of housekeeping announcements. One, closed captions are on. If anyone needs that extra accessibility, you should be able to press show more and click your captions. If you have any issue with that, of course, please let me know so I can onboard you to get you what you need. And the final piece of housekeeping announcements being questions and answers. Love to hear your questions, especially about a topic like this. I know it's tough in the virtual vortex to feel connected and feel safe to share, and sometimes it's difficult to type what you're thinking. I know, but please don't be shy. Drop your questions into the Q&A. That way we can filter them and actually address them in live time. Our goal is to answer those questions that you have in live time as we are proceeding. Finally, I'm going to move into the introductions. And I'm going to start in no particular order of the amazing speakers that we have. First and foremost, we have Judge Esrick, who has presided as a circuit court judge in Florida's 13th Judicial Circuit in Tampa since 1991. She is currently the administrative judge for her circuit's Unified Family Court, as well as the administrative judge for that court's Juvenile Dependency Court. She chairs Hillsborough County Community Alliance and the Hillsborough County Dependency Court Improvement Panel. She is the recipient of the 2012 William E. Gladstone Award, which was presented annually to a Florida judge who has demonstrated a long-term commitment to safeguarding the welfare and dignity of children. We also have with us today Robin Rosenberg, and Robin is an AV-rated board-certified specialist in juvenile law. She is the Deputy Director of Florida's Children First, the statewide legal advocacy organization that fights for the rights of children in state care. She trains and supports attorneys and facilitates the Florida Dependency Law Center resource for lawyers and judges. We also have Cheryl Sattler, who has worked as a child advocate for more than 25 years. She currently serves as child advocate for Legal Services of North Florida, and as part of the youth justice team at Bay Area Legal Aid in California, providing direct services to children and youth in dependency. She uses her background in research and evaluation to help child welfare stakeholders understand individual cases within the context of local, regional, statewide, and national statistics. And before I turn it over for us to get started into the content, I just want to say how honored I am to share this platform with these amazing women. And I thank you for being here, for all that you do and all you're about to teach us today. So the floor is yours.
So before we get started, a couple of people have put in the chat that they can't hear. I don't know if it's unique to them or if everybody's having problems hearing.
I see that, and I believe it is unique to them. I will personally message with some of the folks who are messaging in to see if I can resolve their issues. Can other people in the chat just let us know? Can you hear? Yep.
Okay,
So
good. Okay, I didn't know if we had 160 people not hearing us or 2 people not hearing us.
Awesome.
Okay,
Awesome.
sounds
Well,
like it's isolated to those 2. Thank you
and I will
for
work.
letting us know.
Yeah, thank you all. All right, floor is yours.
Great. Thank you, everybody. I'm glad that you are here joining us today and excited about this topic. This session was originally intended to be presented at the Dependency Summit and was kind of taken off the agenda at the last minute. So we're glad to do it online and have so many more of you be able to attend with us virtually. So I've put up the topics that we're going to cover today in the training. The view from the bench will be inserted throughout the conversation, not tacked on at the end. And we are happy to take questions throughout. So I'd really rather, if you have a question on something that we're talking about, go ahead and try to put it in the Q&A. It's easier to find in the Q&A than in the chat, but we'll keep an eye on the chat as well. And we'll try to get those as we go along. I think we'll have time to cover that and then questions again at the end. So I will spare you singing, but I've called the first one, I Can Call You Betty, because my first slide says you can call me Al. So just starting with terminology, Al is attorney ad litem. And if you don't know, you're not a Paul Simon fan, or I'm too old for you. I apologize.
Or you're not as old as we are. You don't remember that song.
Yes. So I can call you Betty. You can call me Al. So some people use the term attorney ad litem. Some people use the term attorney for the child. Some people say child's attorney. Some people are, you may hear currently, independent legal representation attorney. Whatever you call it, they are all the same thing. We're talking about a person who operates under the rules of professional conduct of the Florida Bar, who has an attorney-client relationship with a child. And the Florida Chapter 39 uses both the term attorney ad litem and attorney for the child without any distinction as to what they mean. So earlier references use attorney ad litem. The Bill of Goals for Children, for example, uses the term attorney ad litem. We worked on the bill for 3901-305, which is categories of kids who get lawyers. We specifically use the term attorney for the child. So they're back and forth, but they are used interchangeably. The term attorney ad litem is not limited to child welfare. If you look in Florida statutes, you will find it in other places, and most specifically, it's used in suits involving property where a putative owner of the property cannot be located to be served to appear in the litigation, and their interest has to be protected in the litigation so that other people can proceed on. And so an attorney ad litem is appointed for a putative property owner for the purpose of litigating that issue of the property. So it's used in other places. Well, how do we get it here in dependency? I believe it's evolved as a useful term, not as a not as a legal term. And what do I mean by that? Before the 1980s, every person who represented a child in court, in criminal cases and in abuse and neglect cases, if their parents were alleged to abuse or neglect them, they were given, if they were lucky, a guardian ad litem. And the guardian ad litem was an attorney, counsel as guardian ad litem. In the late 80s, the National Council of Jewish Women, working with the National CASA program, started some volunteer programs around the state to provide children with the representation provided for under the Child Abuse and Prevention and Treatment Act, CAPTA. And CAPTA said kids could get had to be represented by a guardian ad litem who could be a layperson or an attorney. And nationally, the term that was used was CASA, Court Appointed Special Advocate. In Florida, the people that started those pilot projects very intentionally chose the word guardian ad litem instead of the word CASA. So now we have volunteers that are coming in, telling the court about what the child needs, and their guardians ad litem. So we have also attorneys who used to be called guardians ad litem, but they're not lay people. They're attorneys providing legal advice. Those became, we started calling them attorneys ad litem. So to differentiate that what the child had was an attorney representing the child. So that's where we got to the terms. And I just wanted to do a quick recap on the parties, the counsel, and the roles. I know many of you are attorneys who work in the system and you're familiar with this because you do it day to day, but there are a number of people who are registered for this training who are not attorneys and who are not embroiled in the system every day. So this is just a quick recap. There are 4 parties to a child welfare case. The Department of Children and Families, on behalf of the state, is almost always the petitioner, taking action as to a child, usually against the parent or the caregiver. As a party, the Department of DCF is represented by what's called DCF Children's Legal Services, CLS. It's a subdivision within the agency itself, and DCF agency attorneys represent DCF, with the exception of the 6th Judicial Circuit, where the state attorney has that job. So some of you are in jurisdictions where until recently, the Attorney General had that job, but now everywhere except the 6th, it's an employee of the Department of Children and Families, and their role is to advocate for the safety, well-being, and permanency of abused, neglected, abandoned children. The second party on my list are the parents, and parents are statutorily entitled to the appointment of counsel at the outset of a case. They are, if they're indigent, usually the first parent in the case is represented by the Office of Criminal Conflict and Civil Regional Counsel. Mostly we say regional counsel. Any other parent, or if there's a conflict with the first parent, is represented by an attorney who contracts through the Justice Administrative Commission to represent parents. So we call them registry or wheel attorneys, depending on where you are. Or attorneys can hire, parents can hire their own attorney. Their role is to advocate for their client's goals and to empower the client how to direct the representation, make informed decisions based on thorough counsel. So the DCF role I've taken from CLS material on their website. The parent role I've taken from the Parent Guidelines for Representation. And I did not turn off my phone. Shame on me. And that's where their fundamental role is. And then the next party in the case is the guardian ad litem. The guardian ad litem is a party under Florida statutes and represented by the guardian ad litem attorney. By statute, the guardian ad litem represents the best interest of the child. And by the GAL's practice standards, the GAL attorney also gives legal counsel to the GAL. And then finally, the only reason that we have a dependency case is because of the children. In Florida, children are a party to the dependency proceeding, and they can have attorneys either from the special needs registry, legal aid, law school clinics, or pro bono attorneys. And according to the guidelines for representation for attorneys that represent children, their role is to provide legal services for a child, and they owe the child the same duties that they owe that an attorney owes any other client. So that's kind of the intro to what we're talking about when we're talking about attorneys for children. I'm going to turn it over to the judge to give some reflection on this first section of information.
So before speaking about this section and the other sections that are to come, I just want to make clear that the view from the bench is really just my personal opinion and my personal thoughts. I am not purporting to speak for the judiciary as a whole, for the bench, the dependency bench, or any other groups of judges. I am just giving my personal thoughts after having sat in this division for many years and given my roles in some other statewide organizations and activities involving dependent youth. So as far as what attorneys are called, we in my jurisdiction, I'm in the 13th Circuit in Tampa, we tend to refer to children's attorneys as attorneys ad litem. I do think there's a bit of confusion just sort of generally because we have, and Robin did an excellent job of laying out the history and why it's come to to be as it is now. But I do think when we have guardians ad litem and attorneys ad litem, I think people get a little confused as to what the differences are and who's what. But nonetheless, we either talk about a child or a youth having an attorney ad litem or just, attorney for the child. That's what we tend to use in my courtroom. That's what I tend to say when I'm speaking to a child about their attorney or an attorney about representing a child. There is no difference in my mind. All of they're all synonymous. I try to just use terms that I think that the lay people in the courtroom will understand best. And so particularly and when dealing with young folks who are getting attorneys or who already have attorneys, I try to explain to them that it's your lawyer. I don't say it's your attorney ad litem, even though that's the term we typically use. I'm appointing Joe Schmo as attorney ad litem or Mary Doe as attorney ad litem. But in speaking with a youth, I try to say, this is your lawyer, just like, corporations can have lawyers, adults can have lawyers, kids can have lawyers too. And I explain, what the role of a lawyer is and that they're the client and that what they talk about is confidential and all of those things. But as far as the nomenclature, it makes no difference to me which are used.
Great, thank you. There was a question about whether foster parents are parties. I've answered that in the chat, so hopefully that will answer the question. So the next section is which kids get attorneys? And the answer to that should be any child that the court thinks needs an attorney. So all judges have the inherent authority to appoint an attorney for a party who is unrepresented. And if you want to geek out with me, we can go back to the English law in 1495 and the fact that the Florida adopted common law prior to 1776 when we incorporated the state. So that inherent authority was re-examined in the Supreme Court's decision creating the mandatory pro bono reporting requirement. And it's something I think because we now have such active pro bono and legal aid and other places where you can get pro bono attorneys, we kind of sometimes I think judges don't have in the front of their mind that they have this inherent authority because they can call legal aid to get a pro bono, but they have the inherent authority. All of those of you who are lawyers are subjected to being called on by a court to take a case should the court choose to do that. And then I've also given you some other citations to the Constitution, statutes, and the rules of juvenile procedure, which say that any party can request a court or the court can decide on its own whether an attorney is needed to represent a child. And, and within this, I should have also said, anytime the child gets their own attorney, right? If kids want an attorney and have the capacity, the ability to connect with an attorney who's willing to represent them, kids they can hire their own lawyer. If they can find somebody who's willing to represent them, court appointment is not required. It's usually helpful, and an attorney who's been sought out by a child, if they're under 18 and in a dependency case, I would recommend filing a notice of appearance and asking the court for an order of appointment because it gets you lots of other things that you need. But, there are people that are willing to do it, family, friends, kids know somebody. And if they want a lawyer, they can ask for a lawyer. So court can appoint a lawyer to anybody. The problem is they can't get that person paid. So they can ask an attorney or tell an attorney to take a case, but they can't offer state funds to pay for that attorney. So where do the money come from to represent kids? We're going to talk about the statutory order of appointment in Chapter 39 in a bit, but there are attorneys who are funded in other ways to represent children. So the Florida Bar Foundation funds children's legal services grantees through the Bar Foundation. There are local funded legal aid programs. Legal aid can use Legal Services Corporation funding, Victims of Crime Act funding, other grant sources to pay their attorneys to represent children. There are pro bono programs, law school clinics. So there are lots of different ways that lawyers can be funded to pay for representation of children. Prior to the constitutional amendment change in 1998, we had in some places county-funded attorneys. In Broward County, for example, they had something called the Special Public Defender. And those were attorneys who were paid to represent children in child welfare cases, paid with county funding. With the constitutional amendment change in 98, the counties were not allowed to pay for attorneys. It changed the whole funding system and the court system when it was implemented in 2004. So that went away. But there are other ways that legal aids and others can be funded to represent children. So, Judge, what do you do if you think a kid needs a lawyer and you can't get somebody to paid to do it?
So obviously, as you pointed out earlier, we can always ask attorneys, and we are so fortunate where in my jurisdiction, we have a whole cadre of lawyers who willingly will take these cases on when need be. We also have some local organizations that some for many, many years have represented children. We have our local legal aid organization, Bay Area Legal Services, for many years has had a children's law center with a number of attorneys, and they represent some of our youth. We have a volunteer organization that's been around for over 10 years now, that called Crossroads for Florida Kids. And they too represent youth, not just in dependency, but they take a holistic approach, and they'll represent the child and all their legal needs. Well, not all their legal needs, but if they have needs in dependency court and delinquency court, any holistic approach that requires legal resources, they will provide those resources. And then the group that Robin's with, Florida's Children First, has a lawyer that now represents. They have recently hired a lawyer who will represent children in dependency court. So where I am, we're rich with resources. Could we always use more? Of course, but I have never had. Knock on whatever my desk is made of. I've never had an instance where I felt like a child deserved a lawyer, needed a lawyer, wanted a lawyer, or I wanted a lawyer for them when I wasn't able to get someone to take that on. I'm really mindful of the fact that we don't want to overburden these lawyers who are already working on have too many cases and are not making enough money to compensate them for the hard work that they do. So I really try not to overburden any one particular lawyer, but we ask the lawyers who are on our wheel or our contract that Robin referenced earlier to take on cases on occasion, and they never say no. I've never had one say no. People do this work because they have a passion for kids, for helping those who are less fortunate, particularly those who have been abused, abandoned, or neglected. And I have to say, I see pro bono lawyers take on these cases when we ask them to, and there's no difference. It doesn't matter if they're paid or if they're doing it voluntarily without pay. They work just as hard. They show up for hearings. They meet with their clients regularly. I mean, I could tell you, I could spend the rest of our designated time on this seminar talking about how these lawyers bend over backwards and the things. I mean, I've had lawyers drive a kid up to college and because she didn't have parents. Legally, she didn't, her parents' rights had been terminated. She had an attorney ad litem. One parent was deceased, the other parent was incarcerated, and her attorney ad litem and his wife drove her up to university when she started college, settled her in freshman year, just as other parents settled in their kids. She didn't miss a beat because of her attorney ad litem, who got paid nothing for doing any of that. And that was her home base when she came back from college for Thanksgiving, her first time home, from college. Out of state. That's who she went to for Thanksgiving dinner. These lawyers do far more than file legal pleadings and make arguments in court. They really become a lifeline, often to the youth who they represent.
Thank you. And, I had the very first time we did a training for lawyers with the Crossroads program in Tampa, I had a lawyer come up to me and say, oh, okay, so I'm immune, I get sovereign immunity, right? If I take this case, I'm immune from lawsuit. And I said, absolutely not. You're an attorney, you have legal obligation. And that is why Crossroads and legal aid programs have malpractice insurance. So you have the full expectation that you'll do your job the same as you would for any paying client. Your children have the right to that high quality of representation. And that's why we train and support you and provide you with malpractice insurance, which is not, unfortunately, something that the court can offer, but an organized legal aid program, will offer malpractice insurance to its pro bono volunteers. So I kind of talked about this already. My little history detour of how we got to this CAPTA model and the fact that historically every guardian ad litem for a child was an attorney. So, and I just wanted to reference the seminal case of Henry DB and DS. This was a case where the court had appointed attorneys for children, and then they wanted to get paid, and they did not all get paid. And in the litigation, the court, reminds us that and specifies that at that time, counsel were guardians ad litem. And it's a very interesting case. It's often cited for the proposition that children don't have a constitutional right in dependency to counsel. But I think if you read it, it's actually a lot more nuanced than that. And it's something that the court relied on when it made the mandatory pro bono requirement. So it talks about when the court should be appointing attorneys for children. I see a couple questions. I'm going to put a pin in the first one. GALs do have sovereign immunity under the statute. That's the second question. Okay, so quick history on efforts to create a statutory right to counsel. It goes back to what was originally the Bill of Goals for Dependent Children. It's in 394085, all the things that kids have a right to expect when they're being served by the system. That statute was changed this past year to require the state to do more education to kids about their rights. That was a bill promoted by Florida Youth Shine that we're really excited about. There was a pilot project in Central Florida in 2000. Then there was the Commission on Legal Needs of Children that made a recommendation. Commission of Legal Needs of Children was part of the Florida Bar. So it sponsored and promoted legislation in 2010 that would have appointments of counsel in line with the recommendations of the commission. And that bill failed. In 2013, you all may remember, were a lot of news stories about children who were living in nursing homes and really being stuck there without their family to care for them. And instead of being at home in the community, and there was litigation brought at that time, the legislature's attention was on nursing homes, and we were able to there was a bill to provide attorneys for children in nursing homes. That bill did not pass, but the money was set aside to be administered to hire attorneys for children in nursing homes. So that happened in 2013. And then in 2014 was the passage of 3901305. So this is the statute. We're going to spend some time talking about the children that are entitled to the appointment of compensated counsel. So the law sets out the 5 categories of kids. First category is those ones that I talked about, the ones they were willing to put the money into first. Those are children in nursing homes or being considered for placement in nursing homes. And, the recap, that litigation that started back in 2013 came to fruition this summer in 2023, where the federal court said all the children that are in nursing homes could be living in the community in a family home if they had appropriate care at home. So there are 7 children right now from the child welfare system who are in nursing homes. And there's at least 1,800 children who are at risk of being placed in nursing homes. So these are kids that are very medically fragile, that need medical support and assistance to live in a family home. And if they can't get especially the private duty nursing, round the clock nursing care to keep them alive, they're at risk of institutionalization. So if you come across those children, a lot of times it can be birth defects, near drowning. A lot of these children had near drowning or really traumatic head injuries. And so they're very complicated medically. So if you have kids like that you are working with, and the caregivers are struggling because somebody has to stay awake to clean out a trach or the kid's going to choke to death, they need that round the clock care. If they're struggling to get that, then those kids are at risk of being placed in a nursing home. And the Children's Multidisciplinary Assessment Team, which is the Department of Health term, CMAT, should be initiated, and those kids should be getting an attorney. So think about the kids that you work with. If they're really medically need that type of care, if they don't have counsel, they're probably entitled and should be appointed an attorney. The second category of kids that are in the statute are children who are prescribed a psychotropic medication and they decline to assent. It's kind of a weird way of putting it, but again, think back into history. In 2009, a young boy committed suicide in his foster home. His name was Gabriel Myers. It caused the state to create a task force to examine the use of psychotropic medications and of sexual abuse, because he suffered both, and caused the state to do a really deep look at the use of psychotropic medications on children. And in that process, it became clear that the prescriber is supposed to have a relationship with the child and explain, as you would want with your doctor, about the medication. And this is already the doctor's job and professional responsibility, and to determine from the client, the patient, whether they agree with the course of treatment. And if the children might say, no, I don't want to do that. I will, I know you're going to make me, or I'm being threatened that I'm going to be kicked out of my placement if I don't. So I don't want to, but I'm going to, is where you get assent. So because of that intense scrutiny at the Gabriel Myers task group, the department itself decided that it would ask to have an attorney appointed for children who did not assent to psychotropic medications. So they put that in the administrative code years before the statute was changed. So they were already asking courts. The court just couldn't pay the attorney that they were appointing for those. And DCF's practice for these kids is to ask for an attorney if the child declines to assent, if they're developmentally incapable, so that either could be because they're very young, and we have children under the age of 5 on psych meds in Florida, or it could be that they have a developmental disability that makes them incapable of having that conversation. Specifically, if they have developmental disability diagnosis, or if they say, I really want to stop, right? I don't want to take it anymore. So that's the department's practice on when children who are prescribed psych meds should be appointed an attorney. And we'll take a pause there, Judge.
All right. So, first question, what benefits do I see when kids who do not assent to psychotropic medications get counsel? I think it's so obvious. And honestly, I think the question could omit the part where it says who don't assent. The benefit to kids, whether they're in agreement with the prescribed regimen or not, is the same benefit that any parent or legal guardian who has a child in need of medical treatment wants. You want to make sure that the parent and the child, if the child is developmentally able to do so, understand what's being prescribed, what's being recommended, what the potential risks are, what the expected outcomes are. It's knowledge, because knowledge is power. And you want to make sure there's full understanding and full disclosure. And a child who's developmentally able to understand those things has every right, just as any parent would want their child to understand if they're being prescribed medicine, if they're perhaps going to undergo a medical course of treatment of any type. You want to make sure they understand everything and are given the knowledge and then can make an appropriate, with the advice of counsel, with the input from their caregivers, decision as to whether it's the course of treatment that they want. It goes without saying that children in care have the same rights and the same needs as kids not in care, and we shouldn't treat them any differently. We shouldn't, and it's often in the guise of protecting them, but we shouldn't withhold information from them. We shouldn't keep them from having a say in what's going to happen to them. We shouldn't keep them from full awareness of what their conditions are and what the options that they have are. So this just makes sure that our kids in care are given those same opportunities that other kids have. As far as an age cutoff under which I might, the question is there an age cutoff under which you presume a child cannot assent? And there is not, in my mind. Some younger children are very astute and very wise and very aware. Some older children have the developmental capacities of a much younger child. So I don't have an absolute cutoff when I say that a child cannot assent. I take it on a case-by-case basis. Obviously very young, infants and toddlers, et cetera, cannot assent. But beyond that, I don't have an absolute definite numerical cutoff for an age.
Great, thank you. Okay, next category of kids required by statute are those that are placed in residential treatment centers. And we could have a whole hour talking about residential treatment centers, but I'm giving you the really short version. The term RTC is actually the overarching broad term. And under that come things that you may be more familiar with: SIP, Statewide Inpatient Psychiatric Program, QRTPs, the Qualified Residential Treatment Program, and Specialized Therapeutic Group Homes. So those are the actual placements. They all come under the heading of residential treatment. So that is the category of children. And the reason the legislature included that in the statute was back in 2000, the Florida Supreme Court ruled in MW versus Davis that children should be represented in those proceedings. So if you're going to, some of those facilities are locked facilities. So if you're going to take someone's liberty interest away, they have the right and due process right to be represented and be heard in that decision-making process. So in those circumstances, the minute somebody asks for a suitability assessment, and for those that don't know, suitability assessment is required by Medicaid before Medicaid will pay for that placement. So it's a process, it's required by statute, but it's done in order for Medicaid to pay. If somebody thinks, I think this kid needs to be in a residential treatment, let's get a suitability assessment, the appointment should be made right then, because the attorney can get involved making sure that the assessor has the correct and comprehensive records, provide information, answer questions. If you wait until it's further down in the process, you may end up delaying things because the attorney can point out things that the assessor should have considered at the front end. So again, it was already required by court rule. So putting it in the law enabled those attorneys to get paid. Diagnosed with developmental disability under Florida statute, and the statute is specifically for kids or for people with developmental disabilities that the Agency for Persons with Disabilities will serve. There are the specific categories that APD serves. There are lots of people that have developmental disabilities that do not fall under those categories. If a child was, had a traumatic brain injury, had other physical causes for brain damage that caused them to have a developmental disability, those are not covered under the APD. But there were so many kids in the child welfare system who did have, fall under the categories that would be covered by APD. And especially at the time, there was a concern that APD originally the services were originally part of the Department of Children and Families and then got split out. but DCF was still doing the administrative hearings for APD. And the concern was at the time that the GAL attorneys worked with a sister state agency. And so if they had to sue APD to get services for a kid, they weren't going to do that. They didn't want to have to be put in that position. And it wasn't clear that their attorneys could do that. So there was uniform agreement that this is a big group of kids that need help, and that getting them an attorney in early to sort them out with the services that they need was important. So that category was included. And then last category, victims of human trafficking. So again, at the time in 2014, as now, the legislature really had its eye on what was happening to people who were trafficked, especially kids that ended up in the child welfare system. And because there are so many other legal proceedings that those children may be subject to, criminal proceedings, I think at the time the law went into effect, or very shortly before then, children could be charged with prostitution. And the acts that they were being trafficked for, they were still being criminally charged for. So I don't remember the year our safe harbor law went into effect, but there was just a concern about this population of young people, and that it's not limited to those that are sex trafficked. We have young people who are labor trafficked, exploited, brought to this country and made to do more than chores. And so it was to protect that population of young people. And so those were the 5 categories that the legislature agreed on, the guardian ad litem had agreed on, and we jointly promoted the passage of this bill in 2014. I will take a quick detour to answer the question, why are attorneys the only professionals expected to work pro bono? I can't speak for other professions. So I believe that there are other professions where people commonly, doctors and others commonly offer their services. But, for attorneys, we were given an exclusive franchise. Nobody else can do what we do. And if you read the Supreme Court's decision on the pro bono rule, it would explain the whole history of how we got to where we are and why we are obligated to provide pro bono. So then I will switch back to you, Judge.
Okay, a couple of questions about special needs attorneys. So first question, am I concerned that youth who are trafficked will be further at risk if they can have confidential communications with their lawyers? And the thinking behind that question is some folks believe that having lawyers for kids who have been trafficked might result in kids keeping secrets and not divulging important information with regard to their history. I personally am not concerned about that. I think the benefits, there's risks anytime you appoint counsel for anybody, or anytime a person has a lawyer, that things will be kept pursuant to those privileges, will be kept in confidence. But I don't have, obviously, anytime you have a child who's been trafficked, there are so many risks, and we worry about those kids in particular, of course. But I don't worry that the fact that they've been appointed counsel is jeopardizing their safety more so than if they didn't have counsel. I think for them to know their rights, to understand what's happened to them, to be able to get assistance in working through the system. Sometimes they're having to testify in criminal courtrooms. Obviously, they have to. They have the right to participate and to appear in court on their dependency cases. But for a lawyer to be able to counsel and advise them and to hold their hand, sometimes literally, throughout that process, I think is a good thing. And I don't have concerns that we're placing them at risk. I think we're keeping them from further harm by making sure that their rights are protected and that they are given that counsel and that advice that they need in working through the system, as well as other services that the system should be providing to them as well. Next question. Have I seen counsel for trafficked youth assist would help if I read the whole question. How have I seen counsel for trafficked youth assist their clients? I think I kind of spoke to that already in answering the first question. But again, these lawyers who take on these cases, this is not a 9 to 5, clock in, clock out sort of job, where you're going through the motions. It's not that type of relationship. It's not that kind of job. These are not those kinds of people or lawyers. They take these responsibilities seriously. They are excellent lawyers, and they, as I said, provide advice and counsel through, across the board. And these kids have a variety of needs. And this is a tough group of kids, as you can imagine, oftentimes. They're distrustful often are distrustful of the system, often are distrustful of adults, and understandably so. And these lawyers really do a remarkable job, from my experience, in helping their clients understand what their lawyers' roles are, why they're there to help them, the fact that their communications are confidential, they can confide in their lawyers without risk of it being divulged to others. And I've seen the counsel for a youth involved in these situations really be able to help turn their lives around, and it happens. Does it always happen? No. Does it happen? Yes. Last question with regard to special needs attorneys. Thinking about all the categories, those 5 categories that Robin outlined above, are some more likely than others to have kids slip through the cracks and not get appointed counsel? So I think we're really good at identifying kids who are in nursing homes or subject to being in nursing homes, youth who have been prescribed or are already taking psychotropic medication, children who are in or for whom a request to place in a residential treatment center has been made. Those are pretty easy. Those are boxes you check off. You don't think about it. You have one of those cases come before you, you appoint a lawyer. The last 2 categories are a little more amorphous. The developmental disabilities, sometimes we don't know a youth has been diagnosed with one of those developmental disabilities that are outlined in the statute. Sometimes, again, you may hear that a child has autism or one of the other designated developmental disabilities, but you don't know where that came from. I don't have a document. I don't have an actual written diagnosis, and when you inquire, they'll say, oh, the school diagnosed them with, what have you, or you learn later on. I might be on a case for a long, long, long time, and then all of a sudden there's mention of, spina bifida or cerebral palsy or something that nobody's ever mentioned. We don't know where it came from. Or a parent may say, oh, yes, my child has X. And when I try to find out, exactly what led the parent to think that their child had that, did you actually receive a diagnosis? Can you tell me who diagnosed you, the child, or when or where? Sometimes it's a little vague, and we have to do some digging. So I think those kids do slip through the cracks sometimes, just because the court, and oftentimes all the parties or most of the parties, just weren't aware that there was possibly or definitively a diagnosed developmental disability. Likewise with victims of human trafficking. If somebody's a verified victim, of course, then we know that and we appoint counsel. But sometimes, there are things that come to your attention in that youth's past. They may have been arrested walking outside of a hotel with an older man. Does that necessarily mean they were trafficked? No. Do red flags go up and make you think they might have been? Absolutely. And so sometimes, it's not clear cut that they fall into those, particularly those last 2 categories. So I think those are the ones who fall through the cracks. That's not to say that we can't go ahead and appoint an attorney for them, but they're not going to get paid by the state if we can't show that the child comes into one of those 5 categories.
I have to unmute in order for you to hear me. Okay, so who's covered dependent child in the statute means anyone subject to any proceeding under Chapter 39. So it does not require that a child's been adjudicated dependent. They could be in shelter status. They can be post termination of parental rights, and it includes young adults who are in extended foster care, because the extended foster care statute redefines child to include them for that purpose. So if a kid's remains or returns to extended foster care and is eligible, they're covered by the statute. So real quickly, the process and procedure there, I see some questions about appointment. So the Department of Children and Families has the obligation to identify which children are eligible for representation and to make a motion to the court. I say to all of you, if you see something, say something. If you're in court and you overhear and it's clearly a trafficking situation and the kid doesn't have an attorney, pipe up, tell the CLS attorney, whatever you need to do. Everybody needs to have a hand in it. So CLS current has a handout, I don't know what the term is, has a policy for its attorneys that require them to review at the beginning of a case whether the child meets the criteria and make the motion. They don't currently have a written procedure for periodic review of whether, now that they're in the case, the child might be eligible. So there currently is no way to ascertain how many children are appointed counsel under the statute. It is my understanding, fingers crossed, that DCF-CLS is instituting a new database system that will enable them to generate that data maybe in a year from now. I'm very hopeful about that. The statute permits DCF to create a rule in rulemaking to do this, but it has not chosen to do that. And then the guardian ad litem also has a role. The statute recognizes that we have lots of pro bono and existing legal aid programs. And so this current statute requires that when the court identifies that a child needs an attorney, they ask the GAL to find someone, and the GAL has 15 days to do that, or can say up front, we're not going to be able to find somebody, go ahead and appoint somebody from the registry. And so the court can, if the judge has somebody specific in mind, if they think this child needs specifically this type of attorney with this background, and that attorney is on the registry, the court can appoint a specific attorney. Otherwise, the state registry process requires the court to go in order in a cycle through the registry. Each local court, circuit court, decides who can get on the registry and what the training requirements are. So there is not a specific requirement. For example, somebody's asked about in trafficking cases if they have to have specific training for that. And the state law does not require that. And local courts decide who is on the registry. And for the question of who do you have to go through the judge? Yes, you make a motion for appointment to the court, and the court issues the order of appointment. The scope of representation, it begins as soon as the child is identified and the attorney is notified that they've been appointed to represent a child. It lasts through the duration of the case until the case is closed. And even if the reason that they were appointed is concluded, if the issue is they're going to go into, they're being proposed for residential treatment center, that issue has been resolved, the representation continues till the end of the case. It also extends beyond the Chapter 39 case. That means if the kid has a disciplinary hearing in public school or needs to do a fair hearing because they're being denied a Medicaid service, needs a special ed appeal, the attorney has the capacity to represent the child in those types of proceedings, or can then go to the court and say, my kid needs a probate lawyer. They're inheriting property. I can't do that. We got to get them a probate lawyer. And again, it comes under the traditional attorney-client relationship under the Florida bar. Back to you, Judge.
Okay, so let me just tell you before I go to the questions that are outlined here. So I just got a text from a lawyer in my jurisdiction who wants to add on to what I said earlier. In addition to the things I outlined, this lawyer says, we as attorneys ad litem do the following. attend our clients' IEP staffings, meaning staffings for their independent educational plans at schools, give gifts for birthdays, holidays, etc. When there are siblings, we advocate for compliance with court-ordered visitation with siblings. We speak with children's pediatricians. We involve ourselves in the medication consults. We established a rapport with children who are in SIP placements. Some of us travel far to those placements to visit with our clients. So that just gives you some, just a little thumbnail sketch of what these lawyers do. And they do it lovingly. They do it, without complaint, and they do it because they care. So back to the questions on the screen here. Does the fact that children's attorneys operate in a traditional attorney-client relationship and must advocate as directed by clients give you cause for concern? No. In fact, not only does it not give me cause for concern, it warms my heart. As I said at the very beginning of this presentation, I don't see an attorney-client relationship involving one of the children in our system as being any different than any other attorney-client relationship. Children are people, and they have rights, and they have the same rights as everybody else. And I don't have, and if you came to court and you sat and you listened to these kids, or if you go to a youth shine presentation and you hear what some of these youth, some of whom are in the system, some of whom are no longer in the system, have to say, they're smart, they're savvy, they're aware, and it like I said, is a good thing in my book, and I'm not concerned about it in the least. Second question. We've heard some folks say that if lawyers have to do as their child client directs, they will then have to file frivolous motions, like seeking candy bars at every meal for the child. What sort of frivolous motions are filed in my court? And what about things like motions for tattoos, piercings, etc.? So, first of all, and if I haven't made it clear already, then I'm probably not going to do so today. I think these lawyers who represent children before me do a terrific job. I don't see them, just because a child is direct, and often these children are near adults, mind you. The fact that a child is calling the shots and asking their lawyers to do things on their case has not resulted in frivolous motions being filed. Does that mean that I say yes every time a child's lawyer asks me to do something on behalf of that child? Of course not. Any more than I say yes to any other lawyer involved in proceedings before me. I do what I think is appropriate. I try to follow the law. I do what I think is in a child's best interest. And I've never seen a motion such as, can I have a candy bar at every meal? I think lawyers who represent youth manage those youth's expectations, just like, many adult clients have unreasonable expectations and want their lawyers to ask for things in court that lawyers and judges know are never going to be granted, and probably it's not appropriate to ask for. That's part of the lawyer's job, is to manage their client's expectations. And I think they do a very good job of doing that. But I'm not seeing those types of requests. I'm not seeing, I think youth who are old enough to understand that they have a lawyer and what the lawyer's role is in their case understand that they're not there to ask for, the moon. They're there to deal with the issues that the court is tasked with dealing with. So no, I don't see frivolous motions. I do see motions for tattoos. So oftentimes I think of my role in handling things such as motions for tattoos and piercings, etc. Much as a parent deals with requests that your child makes, right? Sometimes your child asks you for things that you're never going to agree to. Sometimes you can't agree to them. Sometimes you just don't want to agree to them. And sometimes you don't think it's safe or appropriate or what have you. I do get things like motions for tattoos, and I'm sure any parent who has a teenager who wants a tattoo goes through the same machinations in dealing with their own child that I go through in dealing with requests from children whose cases are before me. What worries me about tattoos, unlike most other requests, is that it's permanent. And so I'm going to err on the side of caution with anything that's a permanent decision. And I often say no to requests for tattoos, and I tell them, I'm saying no because this is something you're going to have to live with for the rest of your life, and I want to make sure you're absolutely certain of it, and I think you should be an adult to make that decision. Having said that, I have sometimes agreed to tattoos. I often have children who already have tattoos asking me for additional tattoos. And that obviously puts them in a different situation than if it's, a younger child who doesn't have tattoos. So do I relish getting those kinds of requests? Of course not, but it's part of my job. Just like parents have jobs involving their children and tasks involving their children that they wish they didn't have to take on. But I don't think that the lawyers are requesting things that are inappropriate or frivolous.
Thank you, Judge. Okay, I'm going to give you a little bit of quick data on the number of appointments for children. This is the 2022 data, and this is just those attorneys who are appointed and sought payment through the Justice Administrative Commission. So there are surely other appointments that took place that were pro bono or legal aid attorneys or law school clinic attorneys who are not reflected in this data. But this is for the categories, the number of new appointments that occurred in 2022 under each category. And, one of the impetuses for creating this training was the fear of the kids slipping through the cracks. So I noted in the last segment of the slide that when PAGA did its 2022 annual report on human trafficking, there were 128 verified victims of trafficking involved in the dependency system. Verification is not required for appointment of a counsel, but that's the tip of the iceberg is 128, and only 58 young people were appointed counsel under the trafficking category. Again, some of them may have lawyers from legal aid and other places, but it just gives us cause for concern that kids are slipping through the cracks. And then the last little piece of data is you can see by judicial circuit, the number of appointed in each circuit. And it's really fascinating if you dig in and know. So the 15th and 17th are Palm Beach and Broward. I can never remember which is which. Fairly low numbers, but those counties have a tremendous number of children who are represented by counsel because their legal aid programs are very robust and represent tons of kids. So it is not a reflection of how many kids around the state have an attorney. It is just the appointments of paid attorneys under the registry by a judicial circuit. I'm going to turn it over to Cheryl, who's going to talk to you about more data and information. Oh, you're on mute, Cheryl.
That is my last trick today. I'm really good about being on mute. Sorry. And before I get started, I do need to say that although I am a contractor with Legal Services of North Florida, this presentation is not on LSNF's behalf. This is my personal data and personal views. So, we've got all this policy out there and all of these good intentions. And so what does it look like on the ground? And obviously, the only way to really look at what's happening is to talk to kids and to ask them, what's going on, which is what we chose to do. And I think, Robin, you have my slides. Yes. So what we decided to do is design a survey. And survey research is limited, and I don't hesitate to say that, but it's also a very quick, easy way to get kids' input. But we wanted to make sure that it was really going to make sense to kids. So I have a PhD. I am an attorney. I'm not licensed to practice in the state of Florida currently. So I took the first crack at developing this survey. And then I think I almost had to turn in my PhD, Robin, because when I gave this to the kids to look at, and I said, look, here's your job. I need you to field test this survey. Do you know what field testing is? And they said, no. I said, I need you to break this survey. And I may have to rephrase that because they did. They went through every question and every answer, and they taught me tons, which was great. And then, of course, we went out with a fresh survey and gave that to a new set of youth, and they cross-checked that. So at the end, we had the same concepts, but a much more accessible survey that, spoke to youth in youth words, which was really important to us, as a sign of respect, really, because we talk a lot about lived experience and youth with lived experience. These are youth living the system, so this ought to be by them as well as for and about them. So we ended up, it's very hard to survey kids in the foster care system because it's not like there's a great big list of them with their email addresses. We ended up distributing the survey through independent living coordinators because those folks are all around the state. They have contact with a lot of youth, and then youth sent it to other youth. But of course, by sending it through those coordinators and by just letting anyone who wanted to answer the survey do so, we end up with a sample of convenience. So that's just a limitation. This is not scientific. It is a glimpse. But we did have a lot of excitement from youth. We had 171 youth who responded in 8 days. Then we had to shut down the survey because we originally only had funding to give gift certificates to the first 100 youth, and we didn't want youth to think they were getting something that they weren't. We never pull punches on youth. I want to especially thank the National Association of Children, Council for Children. They coordinated all those gift certificates, and bless their hearts for doing so. So what did we find? Well, let's find out who answered the survey. So we had 114 youth who were currently in care, and then 65 who were formerly in care. So just give those statistical breakdowns. And we thought, well, you know what? These are really different groups of kids. One group is thinking back on their experiences, and one group is living it right now. So let's look at these separately and see whether there are meaningful differences. And then we also wanted to acknowledge that things are a little different in Broward, Palm Beach, and Orange counties. So Broward and Palm Beach, as Robin just mentioned, have really robust child representation programs, and they just are kind of a thing apart. And then in Orange County, any child who has a guardian ad litem has an attorney as that guardian ad litem. And so that got really confusing, but we didn't want to limit the survey. We didn't want to say, if you're from Broward County, don't answer this survey. So that's the way we ended up handling that issue. These are just the ages. So we had kids as young as 15 and as old as 27 answering the survey. You can see about half of those kids who are currently in care have been in foster care more than once. We won't talk about the foster care cycle. But the majority of both groups had been in foster care between 1 and 3 times. So we're not getting the real outliers, the kids who have had 60 placements. This is a pretty typical group of kids in terms of, although it's not a scientific sample, we can say that they're fairly typical of kids in the system. This is just a race, ethnicity, wanted to make sure that those groups were fairly equal. I won't talk about disproportionality here, but these data support the fact that there is an overrepresentation of students of color, kids of color in the foster care system, much greater than their presence in the state. And then because so many issues come up around sexuality, certainly we've had cases of kids who are transsexual, kids who are gender fluid, just wanted to see what those kids had to say and wanted to make sure that the sample included them. It would have been nice if we had gotten more of them, but that's a very difficult and personal issue. And obviously, we wanted to prefer not to answer because it's none of my business if you don't want it to be my business. So what did they say? And this to me is the most important slide. First of all, there was so much confusion over whether kids had an attorney or not. And, fundamentally, I think if kids, like, you should know. It's like knowing that you have a doctor or not, or knowing that you have breakfast or not. It should be something that's certain. And we had youth who said they didn't have an attorney who answered the attorney questions. We had youth who said they did have attorneys who answered with very strange responses. And I think going back to Robin's very first slide or first set of slides, there is a lot of confusion among adults between AAL and GAL. And so that's reflected in kids too. There is confusion. In terms of the data, what we did is to go back to those kids who said no attorney and not analyze their answers to attorney questions, and kids who said they had an attorney who answered in a way that suggested they didn't. We just took those out of the analysis. We would love to go back to those youth and get some more idea about what was going on. But again, that's quite difficult to do. So who qualified for attorneys? And this is just the statutory criteria, those 5 categories that Robin so aptly described for us. So in our sample, 41% of those 171 kids would have qualified under statutory criteria. And then 59% were not. So what's the big deal? Well, I broke that down and looked at the 5 categories and said, all right, if we had every kid who actually qualified for an attorney, was appointed an attorney, what would that look like? Well, I had 19 unique responded to a developmental disability, 62 that were on psychotropic meds. You can see all these numbers here. And interestingly, none in a nursing home, but given that there's only 9, I guess we didn't capture any of those 9. And then so we go back to psychotropic medications and say, all right, well, we asked youth if they were on psychotropic meds, but we didn't ask them if they assented, in part because that's just a really legal definition that, on a survey, it would take 3 pages just to explain that. So we took out those kids who were on psychotropic meds, just took that category out. So I went from 80% that would have qualified to about 41% qualified. That's quite a few kids, and it's quite a bit higher than what we are seeing. So this is just putting that same data in a pie chart, conservatively estimating. So I included none of those kids on psychotropic meds. 41% of respondents qualified for attorneys. And you know what, Robin, I actually think this is the old slide that I replaced. So maybe when we update the deck and send it out, we can give people the right one, because I think there's a different table there. But that's okay.
All right. Yeah.
Let's look at the next one. All right, great. So now that we know which kids had attorneys and which kids didn't, and which kids are confused, did it matter? And, this is not a statistical thing. This is at the end of the day, do you, as someone with an attorney, feel like they made a difference? And I have to say, this was really hard to summarize because these kids said amazing things about their attorneys, and some of them named the attorneys, and kids who had been out of the system for 10 years and still knew their attorney's name and probably still had them on their phone. Anyway, so what we saw was that when youth had attorneys, they more frequently lived in family homes, which we all know from the research is a much more positive experience for youth. We also saw that fewer youth with attorneys lived in group homes. Group homes, very restrictive environment, very poor outcomes for youth in foster care. Also, one thing that was interesting was why they exited. We saw that more youth were adopted when they had an attorney. And that, again, is consistent with the scholarly research in this area. But one thing that was new to me and I thought was very interesting was that fewer youth exited to criminal justice when they had an attorney. So they did not become crossover kids. They did not go from a foster home to a DJJ residential facility or to a jail or prison. And that's, sort of odd to discuss it like that, but that's a positive outcome for kids. And the last thing I think is that we saw big differences with kids' experiences in court itself. And all of you, or many of you on this call, have been in a courtroom, you know how intimidating it can be. So when youth had attorneys, they got to go to court as often as they wanted to. And that is an important right of a child. And this is their case. This is a case about their life. And, almost twice as often. When they were in court, they reported that they understood court. So we had a whole scale there from you always understood court to you never understood court. And 14% of those who didn't have attorneys were like, yeah, I never knew what was going on. So they were there, but how helpful was it? And this one kind of bothers me. So I'm hoping that the judge will weigh in on this. Judges were much less likely to ask for youth input when the youth didn't have a lawyer. Now, we all know that everybody has the right to address a court, but youth are sometimes pretty reluctant to do that unless called on specifically or invited to chambers to do that. So that big difference was a little disturbing. And then this is probably, hand in glove with the last slide. When a youth did not have an attorney, they didn't like their judges. They thought their judges didn't listen to them. Their judges didn't respect them. Their judge didn't explain what was happening. And so what's happening in their case, what they were deciding and why. And the judge didn't explain the law. And this is entirely consistent. And I think goes to sort of the fundamental, Judge Esrig said, children are people with rights. And when they don't have attorneys and they're not aware of those rights, it colors their entire experience of what happens in court. So just to make some very preliminary conclusions, we see a very large gap between youth who qualified for an attorney and those who actually were appointed an attorney, those kids who fall through the cracks. There's lots of benefits that kids report when they have attorneys. And those benefits go beyond just personal benefits, where they live, who they interact with, but also to how they respond to the judicial system. And, as one of the three branches of government that we all interact with, raising kids, particularly system involved kids, in a way that they understand and appreciate the judicial system, I think is a fundamental value we don't discuss often enough. So, Judge, I've asked you a couple of questions. What's your response to that data, which I know is new to you?
Oh, you're on mute.
Sorry. It is new to me, but I've had a chance to look over it. I would like to say it's surprising. It's not surprising. It's a poor reflection on the courts in a certain way. Obviously, and I think we need to remember that it's not just youth. We have people come to court. We talk about access to justice. We want everybody, but especially our youth, to be heard, to understand what's going on, to make sure that due process is followed. And we need to ensure that that's true of all. And I'm conscious of this when we have people for whom English is not their first language, whether they're an adult or a youth, people who have disabilities of any type, physical or intellectual. So I think we just need to be mindful and cognizant of the fact that every litigant, regardless of age, stature, country of origin, et cetera, should be able to participate fully and with as much knowledge and counsel and advice as we can give to them. So I'm not surprised that youth who do not have attorneys feel excluded. My word, not theirs, I realize, but if you look at the survey, they don't understand, they don't feel heard, they don't feel respected, they don't understand. No surprise there, no surprise whatsoever. And unfortunately, we're not to a point yet where every child has an attorney. And so we're always going to have youth without attorneys, or I shouldn't say always, but in the near foreseeable future, we're going to have certain youth who don't have attorneys. And it is incumbent on the court to ensure that they are heard, that they are respected, that they are cognizant of what's going on, and hopefully that the judge will walk them through the process and explain anything to them, and not talk in acronyms and abbreviations and things that people don't understand if they're not lawyers or judges. So it certainly goes, and I think it's clear, whether you look at this data or not, that there are many benefits to youth having lawyers. So that's not to say that youth who don't have lawyers aren't entitled to the same things as youth who do have lawyers, but I do think it's incumbent on the courts in particular to bend over backwards to make time. And, time is the big commodity here that we haven't really spoken of. We're all hurrying all day, every day. I'm looking at my watch all day, every day. Am I giving this case enough time? Are there people waiting in the wings for the next hearing? And it's that balance. And of course, when you have a lawyer who's synthesizing things and filtering things and doing things behind the scenes, then it makes it much go more quickly and more smoothly as a general rule. But it's still, and we've all been there, whether you're a lawyer or a judge in a case where they say there's just one thing that my client wants to talk about, and you realize, oh my gosh, this is a big deal, this is going to take the next 30 minutes, which we haven't allotted for. So what do you do in those instances? Do you say, too bad, I'm on a tight time frame and we've got people with a hearing scheduled now, don't have time to hear you? Or do you say, that's really important and I want to make sure that I don't give you short shrift? And so let's find a time. I didn't allot an extra 30 minutes here, but you matter to me and this issue matters to me. So why don't we come back? I will give you a designated slot when we're going to be able to discuss this fully. I mean, that's what I say to people. Or if I can work it in, I'll work it in right then and there. But again, it's treating people with dignity and respect and not trivializing what is important to them. I think that's paramount. And I would hope that every judge hearing these types of cases is aware of that and takes it to heart and lives it. We all have moments when we're not at our best, but overall, we want to live that and we want to be, fair to all litigants, but including our youth.
Thank you so much, Judge.
I want to pull you to one of the questions in the Q&A. Somebody wrote, what's the best way to approach a situation where the judge is refusing to appoint an attorney for the child because the GAL says they're representing the child's interest fully, but there's a clear conflict of interest between the child's wishes and the GAL's perception of best interest? That's a tricky one. I do get people calling me about that sometime, but I like to hear your thoughts about.
Well, it's obviously difficult if a judge has ruled, has said no, and you want the judge to say yes, and you don't want to argue with their ruling. I do think it's the kind of thing, I don't know if we have a lot of opportunities through things such as we have court improvement meetings where we all come together, all the stakeholders in the dependency court system, to talk on an equal basis about systemic matters. We don't talk about individual cases, of course. We can't have ex parte communications, but we could talk about systemic concerns, issues. And so I think that as a start might be a good place to begin, to just say, I see cases where there could be, and in my opinion, should be, both an attorney ad litem and a guardian ad litem. And here's why systemically I think that can be helpful to children. And of course, you've now got this survey that Cheryl just went through. OPAGA, I've got some data that OPAGA did a similar survey, and I won't read you it, but it's the exact same thing. Kids with attorneys have better results overall when it comes to time in group settings or foster care, time to adoption, time to reunification, et cetera, et cetera, et cetera. I do think too, OSCA, the Office of State Court Administration, they do a lot of training statewide for judges. There's a statewide dependency court improvement panel that at least one judge from every circuit sits on. So you may want to reach out to OSCA. And again, not to talk about particular cases, but just say, I'm in such and such a circuit. I think maybe the judges in my circuit could use some training on the distinctions between attorneys ad litem and guardians ad litem and that sort of thing. So that would be my suggestion.
Yeah, it's a roundabout way. The person asking the question didn't specify whether it's someone who's entitled to appointment under the statute or
that's different.
A perception of conflict. And, if there is a time, you never want to have to go an appellate route, but
sure,
there is an appellate route if there's a clear statute legal duty and
sure,
it's not being followed. So.
Absolutely. I presumed this was where it was discretionary, but yeah, I would agree.
Yeah. So the last couple of questions that are directed at the statute, whether every child should have an attorney. I guess I will just answer that personally. I believe, yes, every child in dependency should have both an attorney and a guardian ad litem. I think they're very important but distinct functions, and that our children would benefit, and their children and the court system would benefit if each child had both. We're coming up on time. Anyone that would like to talk with me about the legislation from last year, that was not the purpose of this meeting. Happy to talk to you about it. As a general proposition, I'm very supportive of these 5 categories that are in the statute. And I'm very concerned that any law that would take away the 5 categories would be detrimental to children. And that is what the bill, last year's bill and this year's bill that has already been filed would do. Are there other things that could happen to make it better so that kids can get the benefit of both in more situations? Absolutely think there's a way to do that. As filed, I have lots of concerns about what that bill would do for these children that are entitled to the appointment of counsel now, and in the interference in the court's discretion, because the bill requires a competency test before the court would have the ability under the statute to appoint an attorney. And competency test has no place in representation. So, but I could go on and happy to talk with anybody that wants to talk about it specifically. Really appreciate your time, Judge and Cheryl, and thanks to everybody who attended. Great conversation, and let's keep it on. If people want to talk about stuff, you know where to find us. Or find me. I'm not offering anyone else. You know where to find me.
And, in the meantime, while folks are thinking about anything last minute they might want to share, I just want to say the CLE code, put that into the chat. That CLE code is 2309461N. I'm going to repeat it again. I should actually just put it in the chat first. 2309461N as in Nancy. And folks, you'll receive that CLE code in that email from Zoom within 24 hours, along with a copy of the recording. So don't worry if you can't jot it down now. Keep your eyes on your inbox tomorrow. Again, my email address is at the top of the chat. If you just want to, extract that. Well, it's in the middle of the chat, kind of. I'll re-put it in there. If you want to extract that in order to reach out to me directly. Last quick thing I'm going to say before turning it back over, to Robin to wrap us up is if you do need a certificate of attendance, that's my job. So again, my email is going to go into the chat. And please reach out to me directly. asking for those certificates. That way I can get them to you directly. Email address is popped back in. And before I turn it over, thank you both. All three of you, I'm sorry, not both, for being here, for providing this training, for all the awesome stuff that you do. It's just so cool to sit here and listen and learn. And with that, I just will turn it back over to Robin for any last, wrap up.
I think we're done. We'll get you out on time. Thanks everybody for attending.
All right, everyone. So we'll hopefully be able to do another CLE soon. I always love partnering with Florida Children First. Honored to share this platform and hope that everybody else has a fantastic rest of your day.
Thanks, everyone. Appreciate your being here.
Thank you.